Well, it's just 4:30 by the law school clock, so I think we'll get started. Welcome to the third in this year's series of Clyne Lectures by Professor Stephen Toope, which we hear and relish and discuss again on the traditional, unceded and ancestral lands of the Hunkaminam-speaking Musqueam people. In that connection, let me mention now that next week, because of the kind of curious and really rather exciting pile-up of Clyne Lectures that has taken place because of COVID, our other current Clyne lecturer, Michelle Good, author of Five Little Indians, will be introducing the next of her guests in the series of Clyne Lectures that she is hosting for us on Zoom from Green College next Tuesday, September the 14th, 5 o'clock on Zoom, and you can find all the information at the college website. Her guest will be Raven Sinclair from the School of Social Work at the University of Regina, who will be speaking on the topic From Residential Schools to the 60s Scoop, a Time of Reckoning. Next Tuesday, via Zoom from Green College. Back now to this week's Clyne Lectures, that a beginning be made a rule of law for our new age of anxiety. Lecture 1 provided a diagnosis. The second lecture gathered resources for an assault on that complex problem. And now, in Lecture 3, we really make a start on things. A new beginning for the rule of law. Stephen Toope.
Well, since this is the last lecture, I do want to say another word of thanks to Green College and to Mark Vesey for a wonderful welcome and for this tremendous opportunity to think about issues that I have been struggling with really for my whole career, and to be able to pull them together for the purposes of this series of lectures has really been for me a great honor and a treat. Behold the infant, helpless in cradle and righteous still. Yet already there is dread in his dreams at the deed of which he knows nothing but knows he can do. The gulf between him and guilt beyond. He jumps and is judged. He joins mankind, the fallen families, freedom lost, love becomes law. W.H. Auden, The Age of Anxiety. In my first lecture, I traced out sources of the pervasive anxiety that marks our age. There are many deep uncertainties, more unsettling than calculable risks, affecting our perception of both present and future. I emphasized 3 because I believe they underlie many others. Populist nationalism, the economic, social, and cultural complexity of globalization, and profound technological change. The second lecture explored the intellectual resources at our disposal to confront these uncertainties, to alleviate our anxieties. Those resources are considerable and plural, drawing upon diverse sources of inspiration, including classical thought, pragmatist philosophy, sociology, and practice theory in the social sciences. I articulated a hope-filled, but I believe realistic means to address pervasive worry. Guided by purposes, people and societies gain practical wisdom through experience over time. Uniquely amongst animals, through continuous self-reflection, we deploy reason, but also intuition, emotion, and social skills. We learn, and we do so through communities of practice, in actions and in discourse. Drawing upon background knowledge, we selectively replicate past practices, deploying our practical wisdom to guide us through new material circumstances and new discoveries or insights. We are fundamentally creative beings, influenced by tradition and habit, but not fully constrained by them. Our world is a world of dynamic becoming. That becoming is not necessarily positive. We must work hard to make it so. The conceptual framework I've laid out, one that helps to build a sense of purpose and hope, brings us to a question that has preoccupied me for most of my working life. What is law's contribution to this world of becoming? Could a reformed rule of law play a role in allowing us to navigate through our new age of anxiety? In the mid-2000s, I served as chair of the United Nations Working Group on Enforced and Involuntary Disappearances. The working group sits under the UN Human Rights Council and consists of a 5-member panel of independent experts. The goal of the working group is entirely practical: to discover the fate of disappeared people. In most cases, sadly, this will be a confirmation of death. But the working group has discovered the whereabouts of many disappeared persons in informal and illegal custody. The methods of the working group are also pragmatic, negotiating with governments and sometimes subjecting them to public embarrassment when diplomatic efforts have stalled. In 2004, I led an official visit of the working group to Nepal. A rapid escalation in the number of disappearances in that country had followed the breakdown of a ceasefire between the government and Maoist guerrillas. One of the strangest moments of the visit was our formal audience with the last king of Nepal, His Majesty King Gyanendra. He had come to the throne only in 2001 as a result of a massacre in the royal palace. Gyanendra's brother, King Birendra, was killed by his own son, the crown prince, who then shot himself and other members of the royal family. The survivor, King Gyanendra, received us in a lavish reception hall and projected the image of a modern constitutional monarch. For various reasons, I've met 3 monarchs of constitutional democracies in my time, and I would not have been able to distinguish the discourse of King Gyanendra from any of them. He was calm, confident, and said all the right things about protecting human rights and upholding the rule of law. It might all have been quite believable if the working group had not visited the headquarters of the Royal Nepalese Army the previous day and met with the military leadership. Our conversation there revealed who was really in control, not the government and certainly not the king. Indeed, credible reports suggested that the king was serving as the instrument of the military. He was deposed only a few years later, and a republic declared, ending the 240-year reign of the Shah dynasty. We'd already learned over the early days of our visit that government security forces, including the army, were systematically committing the international crime of disappearance. At the royal palace, I had been treated to the facade of the rule of law, but the arbitrariness of power and its brutality gainsayed the bizarre show. In Nepal at the time, the military controlled the government and the monarchy, and it abused its power with almost complete impunity. One of the most shocking experiences of my life was a clandestine meeting I held in Nepal with mothers of the disappeared. Their stories were harrowing, but a real moment of personal crisis occurred when I was pulled aside by one mother, probably in her 50s. She quickly told me about the disappearance of her son more than a decade before. She started to cry and said that she had done everything she could to find him. She then took my hand, looked me in the eyes, and said, "I have only you. You are my God." I could barely breathe. No matter how hard I tried, I could not meet her expectations. So I babbled something about raising her son's case with government and expressed deep sympathy. I said that I could not be anyone's God, but that I would try my best to help. As I was ushered away by UN officials, I knew in my deepest being that laws and institutions alone cannot eliminate suffering. It's experiences such as this and others in various parts of Africa, Cuba, Jamaica, and Southeast Asia that force me to admit that the rule of law and specific legal rules cannot provide all the answers to social ills and predicaments. Law is not dominant in, nor even uniquely capable of, guiding us to greater social and individual well-being. But law does have a profound contribution to make, along with other frameworks of analysis and creative discovery. The rule of law does not define well-ordered and healthy human societies, but it is one of the anchoring practices, a constellation of ideas, discourses, and concrete actions that can help create and sustain freedom and equality both nationally and internationally. A sophisticated yet modest conception of the rule of law can be an important element in a collective effort to reinstill a sense of hope in a population troubled and confused by prevailing anxiety. Building upon the approach to social and political theory that I set out in Lecture 2, I want first to address a quite fundamental question. How do we best understand the relationship between law and politics? In discussing populist nationalism, I've already explored one possible answer, that law is entirely subservient to politics, a mere instrument in the hands of those with material power. That was certainly the case with the army in Nepal in 2004, but this argument has many variants. The most extreme is the one put forth by Carl Schmitt and his Nazi fellow travelers. For Schmitt, politics was all-encompassing, a dominating force that overrode all other forms of social organization. Above all, politics was the will of the people, the expression of popular sovereignty, not, as for Aristotle and his successors, rational thought and persuasion. The extremes of Schmitt have been softened in our era, but some of his insights still influence contemporary debates, often unacknowledged. Most pointedly, many scholars of a self-described critical bent argue that politics remains the dominant force in social life because it is the frame that most explicitly recognizes the role of power in social relations. It's argued that fields such as law and human rights pretend to create level playing fields, but that is largely false. Scholars in these subject areas, especially if they can be described as liberals, are viewed as mere apologists for the status quo, as justifiers of hegemony, as insensitive to material factors that create and sustain, even reinforce, underlying social and economic inequalities. On this view, and as an inheritance from Schmitt, law is really nothing more than an instrument in the hands of the powerful. For Schmitt, this was a virtue, and to be fair, for critical scholars, it's a conclusion rooted in a desire for realism and an antidote to the expansive claims of those who promote a dominant role for law in all social organization. For many political theorists, especially theorists of democracy, politics is superior to law in a different structural sense. Modern constitutions are generally understood as emerging from the people in an act of constituent power. The implication is that the people exists outside the law, and the government of the state is created through the people's political will. Legitimate law must therefore enact the political will. Yet, from the earliest Enlightenment justifications for democracy, popular sovereignty was only ever a theoretical construct, and it was not seen as an ideal. Early theorists, including Rousseau and Madison, often cited as originators of modern democracy, did not exalt popular self-rule. Hannah Arendt argued this point in her influential comparison of the French and American revolutions, suggesting that the former consumed itself precisely because it idealized the morality of the people, disconnecting itself from any practical institutions like law. The American revolutionaries, in contrast, drew on social traditions, including legal traditions, to account for the role of power in political life. A great German-American constitutional scholar, Matthias Kumm, poses the central question provocatively, and I quote, "What if the idea of sovereignty as ultimate authority, a conception of constitutional law tied to the coercive institutions of the state, and a conception of legitimacy and democracy reductively tied to the self-governing practices of we the people, is deeply flawed and implausible?" End quote. Is there a better, more accurate and fruitful description of the relationship between law and politics in contemporary societies? Well, I believe that there is. The key lies in the argument that legality is legitimated in a relatively autonomous way and is not dependent upon a political constitution that predates law. Legal systems are held together by, quotes, "those intrinsic qualities that give law its authority and without which there is neither law nor authority." David Deisenhouse. If law is legitimated through its intrinsic qualities, this suggests a circular understanding of legality in which authority is internal to law. This leads to a more robust account of law's role and effects in society than a linear understanding which must locate law's starting point in something other than law itself. A circular understanding allows law to serve its crucial function as a check on power, not its mere instrument. In this tradition of thought, which is rooted in Aristotle's rich understanding of rhetoric, life's challenges call for creativity in drawing analogies and in finding similarities amongst seemingly different elements, thereby creating new understandings of reality. This process is the mature exercise of judgment, or practical reason, a demonstration of prudence in the light of experience over time. I now want to describe how this set of processes plays out in my favorite approach to legal analysis. Over the last 20 years, Jutta Brunet and I have developed what we call an interactional understanding of law, connecting insights from international relations constructivism and practice theory to the legal theory of Lon Fuller. In developing our understanding of the rule of law and of the role of legal rules in contemporary societies, Brunet and I were influenced by Fuller because, amongst 20th century legal theorists, he was the most insightful in explaining the essential horizontality of all law. By that I mean that Fuller argued that what is often assumed to be a vertical relationship of authority and subordination is better understood as a reciprocal relationship in which citizens, quote, accept as law and generally observe a known body of rules, and in turn are able to expect of the government that it will abide by and apply those rules. The conceptual apparatus of IR constructivism also provided useful insight into the emergence, maintenance, and operation of social norms. Constructivists argue that norms are standards of behavior created through mutual expectation in a social setting. And further, that the identity and behavior of social actors is made up of culture, ideas, institutions, discourse, and social norms. Together, it is these elements that shape the perception of interests by which we operate. In other words, interests are not strictly speaking chosen at all, but are constructed in social interaction and shaped by identity. In turn, practice theory illuminates the dynamic interplay between actors pursuing their ends and legal norms enabling, guiding, or constraining them in these pursuits. More specifically, it helps us understand law as a distinctive set of practices focused on interpretation, justification, contestation, and creative action that is rooted in overlapping communities of practice. Practices of law do not create or sustain immutable truths. They provide frames rooted in constitutive rules that may themselves change over time if they're not constantly reinforced through continuing practice. Now, drawing on these influences, the Interactional Law Framework has three interrelated elements. First, Brunet and I posit that legal norms can only arise in the context of social norms based on shared understandings, pragmatism's background. Second, what distinguishes law from other types of social ordering is not simply provenance from a particular hierarchical source, the sovereign power, the legislature, a court, but adherence to a series of internal criteria of legality that were comprehensively but not definitively described by Fuller. When linked to these criteria of legality, social norms can become relatively fixed as law, but the fixity is never permanent. Our third key point is that reinforcement, adjustment, or demolition of legal norms takes place in and through continuing practices of legality. These practices are crucial in generating a distinctive legal legitimacy and a sense of commitment among those to whom law is addressed. And this is what creates law's sense of obligation. As long as legal rules are grounded in shared expectations and largely meet the criteria of legality, law serves as its own source of authority because it's viewed as legitimate by the people to whom law is directed and through whom law is created. It will have built its own epistemic practical authority, to go back to Adler's comments from yesterday. Adler defines such authority as the legitimate power to rule on the adoption of practices and their meanings. Inversely, when a practice of legality degrades, that is, the criteria of legality are no longer met in practice, or failure to uphold the norm becomes endemic, legal norms, and indeed entire legal systems, can be undermined or destroyed. A dramatic example of how these shifts occur is the fate of capital punishment across many different legal systems. Where once the idea of putting people to death for capital crimes was widely accepted, in many societies the shared expectation began to change. Civil society, religious, and legal communities of practice started to question the legitimacy of state-sanctioned killing as a punishment for crime. The issue took on international dimensions as some countries, notably Germany, international NGOs, and intergovernmental human rights organizations launched campaigns to halt the application of the death penalty. Public opinion, shared understandings in many parts of the world started to shift, and formal legal institutions began to make decisions that undermined the rules concerning capital punishment. Juries sometimes refused to convict in capital cases, or judges found ways not to impose the penalty, deploying mechanisms of interpretation and delay. Appeal arrangements proliferated, and in many cases, even those people sentenced to death escaped its application. Sometimes legislatures formally abolished the death penalty, But in other jurisdictions, the penalty simply faded away in practice. With this understanding of law in mind, we can now step back and examine in more detail how a rule of law can, amongst its various purposes, help us navigate through our new age of anxiety. One cannot create a rule of law by fiat. It has to be built together in communities of practice and through them engage with the wider community, interacting with the insights and contributions of other communities of practice, and ultimately requiring the continuing confidence of the wider population. Furthermore, even when it's built up and continuously supported, the rule of law alone cannot eliminate all social ills, as I've emphasized. It must work in conjunction with other socio-political frameworks and institutions, like representative government, free media, and an effective public service. The answers that a rule of law provides to social challenges are invariably mutable, because shared investigation, interpretation, contestation, and reinforcement through concrete action never ends. As Hannah Arendt teaches us, human action and reaction is continuous. Change is endemic. In our era, I've argued that three fundamental sources of anxiety can only be addressed effectively through the building up of epistemic practical authority across a range of interacting communities of practice. The rule of law is one of the most powerful forms of epistemic practical authority, if it's built in ways that I will shortly describe. And that's why it has a central role to play in helping our societies manage and lessen debilitating anxiety. The rule of law is a famously slippery concept, with many definitions offered up over time. The English jurist A.V. Dicey, who is commonly thought to have coined the term rule of law, postulated three components: that government must rule through law crafted in the ordinary legal manner and not through discretionary action, that citizens and government officials are all equal before the law and subject to the ordinary law of the realm, and that the jurisdiction of ordinary courts in particular cases, this is a commitment to inductive reasoning, is the best source of legal protection rather than reference to general principles of the Constitution or supposedly universal concepts. The common thread in this is the commitment to the ordinary in constitutional practice and interpretation. For Dicey, constitutional rules were not exceptional, but part of the warp and woof of everyday law. Though often criticized, this conception has been highly influential, with contemporary thinkers relying on tripartite frameworks, often implicitly. The central division of opinion in discussions around the rule of law is typically framed around the metaphor of a thin, largely formal, or perhaps more accurately procedural rule of law versus a thick rule of law replete with substantive obligations. Distinguished jurists, including Lord Bingham, late of the UK House of Lords, and influential scholars like Oxford's John Finnis, argue the necessity of including social goods such as freedom and protections of human rights or natural rights within the rule of law. The rule of law and concepts of justice are, for these thinkers, intimately connected. The common justifications for the thick version of the rule of law are that procedural guarantees are not enough to preclude abuse and tyranny, and that core moral values cannot be protected by legal procedure alone. An alternative, more procedural understanding of the rule of law is associated with the heritage of Dicey. Although Dicey did focus on what he called the special attribute of English institutions, and that there he was focusing on courts of general jurisdiction, Dicey was not thereby importing extensive substantive rights and freedoms into the rule of law itself. He was only suggesting that if a society wants to protect rights, courts are one of the best ways of doing so because inductive reasoning is safer than attempts to inculcate high principle through law. Much later, Habermas also argued for a procedural or formal, what he called paradigm of law, that did not favor a particular ideal of society, a particular vision of the good life, or even a particular political option. The key here is that for theorists in this tradition, the rule of law does not require the adoption of a single version of the ultimate purpose of society, law and politics. Diversity, at least some diversity, is supported. I don't think that we have to choose between dichotomous positions, the purely formal or the purely substantive conceptions of the rule of law. Lon Fuller insisted that notwithstanding their essentially procedural nature, legality requirements would make it harder in practice for substantive injustices to be perpetrated by legal means. And here I'd like to quote him at some length. It's been said that most of the world's injustices are inflicted not with the fists, but with the elbows. When we use our fists, we use them for a definite purpose, and we're answerable to others and to ourselves for that purpose. Our elbows, we may comfortably suppose, trace a random pattern for which we are not responsible, although our neighbor may be painfully aware that he is being systematically pushed from his seat. A strong commitment to the principles of legality compels a ruler to answer to himself not only for his fists, but for his elbows as well." End quote. This is a fundamental point. Limitations on action that are largely procedural can have a profound effect on government's ability to use its elbows to push citizens around. Tyrants, or for that matter, many powerful private interests, don't like procedural limits on their freedom of action because they are effective in restraining power. Fuller's discussion of the internal morality of law, what Brunet and I prefer to call the criteria of legality, provides a compelling framework to imagine a rule of law that is primarily procedural, but that contains enough substantive constraint for law to play its necessary disciplining function on the exercise of power. If the criteria of legality were largely met, law could control tyrants, both their fists and their elbows, and ensure healthy political discourse, communication within society, supporting the autonomy of citizens. So these substantive goals of autonomy matched with the need for human communication are included in the rule of law, but not contested political ideals such as specific electoral forms or specific rights claims. An obvious example of law's disciplining role over politics is the requirement that legal rules be made public, or to use the technical term, be promulgated. Only when laws are known will citizens be able to shape their behavior in accordance with a rule, thereby avoiding liability. In tyrannical regimes, secret laws, often termed presidential edicts or public order directives, are deployed to trap helpless individuals. What's more, when laws are known, they can be contested in the public sphere through formal political and juridical mechanisms, or even in protests on the street. My understanding of the rule of law presupposes that law is not grounded simply in the will of the sovereign or even of Parliament. It is not merely the fiat of state power, nor is it rooted in a hierarchy of rules. Humans are not subjected to law. Human conduct in its broadest form, including the creation of institutions, is guided by shared and communally created rules. No law, even law in seemingly hierarchical state systems, is merely the imposition of authority or power from above. That's because when understood as a purposive activity rooted in shared social understandings and goals, law depends for its continuing existence on reciprocity, the effective interaction and cooperation between citizens and lawmaking and law-applying officials. Again, Fuller. An important implication, and one that's often misrepresented in common parlance, is that law is not something that can simply be enforced by raw power. Mechanisms of enforcement are, of course, important as part of continuing practices of legality. But only in repressive regimes like North Korea do public authorities depend almost entirely on the threat of physical force to embed rules. In most contexts, law operates because citizens believe it must. They display fidelity to law to advance social purposes, and they're more inclined to do so when they think that public officials are also bound by legal rules. Even in criminal law settings, where state power can be most severe, most of us don't break the law only out of fear of punishment. If we all routinely committed credit card fraud, for example, systems of exchange would break down, and our social and economic purposes would be undermined. What's more, we know that public officials are also bound not to commit fraud and are tasked to create systems of validation and cross-referencing that make perpetrating such fraud difficult. That gives us confidence. The version of the rule of law that I defend is one that helps to deliver social stability. Living in a society where rules are relatively predictable and where government leaders and civil servants are expected to abide by the same rules as ordinary citizens is reassuring. Just ask the people of Myanmar. They'd been moving for over a decade, even if haltingly, towards a country governed by the rule of law, when their expectations were completely overturned by yet another military coup d'etat in 2021. The BBC quoted one anonymous 25-year-old. Waking up to learn your world has been completely turned upside down overnight was not a new feeling, but a feeling that I thought we had moved on from, and one that I never thought we'd be forced to feel again. End quote. In Myanmar, the overthrow of the rule of law undermines the sense that one can project oneself into the future and work towards the fulfillment of one's aspirations. And that is tremendously demoralizing both for individuals and for societies. At the same time, and this is important, my understanding of the rule of law does not inhibit needed social change. It is not inherently conservative. Members of communities of legal practice convince others of their discursive and practical competence, revealed in a range of interacting processes, including interpretation, negotiation, and contestation. In these practices, change can be conceptualized, debated, explained, and brought into being. The rule of law may favor stability, but its content is not fixed in concrete. Because it's grounded in competent practices that are themselves subject to selection and replication, the rule of law is open to diverse influences, accommodating cultural difference. It does not impose a precise set of ends that all societies are expected to pursue in exactly the same way. Its substantive content is limited, but its procedural content is demanding, and that's what helps to establish an appropriate balance between building social stability and shaping change. If I'm right that the rule of law requires competent practice within legal communities of practice, what then are the attributes of competent legal practice? I imagine that amongst the general public, a clear answer would emerge to that question: the ability to argue. The caricatured lawyer is a person who, as a child, always asked, why? And who later had a wiseacre's answer to all her parents' admonishments. Although I argue that law is about much more than discourse and argument, there's no doubt that the sophisticated use of language is a mark of competent legal practice. Debates in law, as in all social argument, require an exchange of reasons, and settled consensus must be open to disruption through future argument. Legal truth, as the pragmatists reveal about all truth, is subject to revision through discovery and reflection in communities of practice. I want to suggest further that there are two particular forms of persuasive argument with strong traction in legal communities of practice: reference to precedent and the use of analogy. Most people are familiar with the idea that lawyers like to quote examples from past practice and past decisions, but why? Is it that law and lawyers are essentially conservative? Many political commentators think so. Is it just that lawyers are committed to the established social order? Well, although I have suggested that the rule of law is indeed a source of stability in societies, I think it's too easy just to assert conservatism. Precedents matter because they draw on several criteria of legality. Having regard to past practice supports the idea that legal rules should be of general application, not being specific to individual status or place or circumstance, although the specifics will be relevant in interpretation. The use of precedent also helps to make the law known, because the rules are not picked from thin air, but have grounding in past experience. Clarity of rules is also aided when one can refer back to how a rule has been understood and applied in the past. All in all, some deference, but not slavish following to past practice, supports the continuing legitimacy of law because it aids in predictability and certainty, attributes often seen to support a robust rule of law. A less obvious, but in my view at least equally important form of persuasive argument in legal communities of practice is the creative use of analogy. Of course, analogy can be related to precedent, drawing on decisions or actions in past circumstance that can be appropriately compared to a new situation. But analogy is a wider concept than precedent and can be deployed by reference to similar contemporaneous situations or to similarities amongst theories, concepts, principles, or rules. Analogy has been influential within the tradition of pragmatist philosophy under a different label, abduction. By abduction, the pragmatist Charles Peirce described reasoning that is an inference to the best explanation. In essence, abduction reflects the everyday problem-solving of human beings, Peirce's ultimate miracle, as he put it, of human practice. People reason from their experience and borrow insight from analogous situations, moments of reflection, and concepts that proved valuable in similar or parallel circumstances. It's no surprise that lawyers should be particularly drawn to abduction because they're so often focused on addressing practical problems that require solutions in the here and now while also projecting into the future. I want to conclude with some thoughts on what the approach to the rule of law that I have traced out means for the contemporary practice of law and for legal education and scholarship. I'll look at the failed practice of some very influential US lawyers in the post-9/11 era to show how the roles and responsibilities of members of legal communities of practice intersect with ethical dilemmas associated with the three contemporary sources of anxiety that I've traced out. Contemporary legal education is often described as helping students to think like a lawyer, as if that were a monolithic concept. What is thinking like a lawyer? For Yale's Anthony Kronman, legal education should excite the moral imagination. But too often, what legal education seems to do is what one observer called domesticating doubt. For all its strengths in logic, our contemporary analytical focus centered around extracting principles from case law can actually serve to distance law students from pertinent complexities of life. To reduce doubt artificially, and with it the reality of uncertainty in life, by reducing the scope of legal thinking to rules-based analytical approaches, is to see law only as an exercise in solving disputes rather than in society building. Comprehending and addressing complexity requires frames of reference, be they called anchoring practices or background. These frames can only be grasped if we connect law to cognate disciplines: philosophy, sociology, anthropology, economics, increasingly computer science, etc. We then draw on precedent and deploy sophisticated analogy and comparison. All this in the exercise of practical wisdom. The potential to invoke practical wisdom is more likely, Aristotle teaches us, if we work concretely to build political and legal norms and institutions that have the capacity to habituate virtue. Doing so allows participants in legal communities of practice to be both reflexive and reflective in our work. Empathy is also required. That is, the ability to enter into the data before us, and more importantly, into the shoes of citizens experiencing the rule of law and particular legal rules. It seems to me that these virtues lie at the heart of what it is to be a wise counsel to others. Students of the law need to develop a refined capacity to see new arguments based on probabilities in situations of uncertainty, and not merely to calibrate risk. We're not then trapped into the dichotomies that seem often to have been assumed in much of late 20th century writing on legal education. Law must be corrected and expanded through external critique, the various law and movements, or it must be acknowledged as a purely instrumental artifact by connecting law only to what clients need and want, law as commerce or law as nothing but politics. Instead, by seeing law as a form of practical wisdom rooted in life experience, the richness of human knowledge can be included within law, but that knowledge is tested in particular ways through communities of legal practice with their internal evaluations of competency, then measured against other communities' valuations of competency. In thinking through what all this means for communities of legal practice, teaching and learning law, and the ethics of law, it's worth considering a high-profile example where, in my view, legal ethics and even the competent performance of legal practice were utterly abandoned in the face of widespread anxiety. In an important executive order flowing from the attacks of September 11, 2001, President George W. Bush determined that, quotes, terrorists and other enemy fighters who did not wear uniforms or carry their arms openly, end quotes, would not be treated as prisoners of war. As a direct consequence, the administration asked its legal counsel to provide new guidance on what sort of techniques could be deployed to get accused al-Qaeda operatives in custody to talk. At the beginning of August 2002, the head of the Office of the Legal Counsel, OLC, in the Department of Justice, sent a memo to the Counsel of the CIA, arguing that 10 specific techniques, escalating in force up to waterboarding, did not constitute torture. On the same day, a second memo from the OLC, written primarily by John Yoo, a young law professor on leave in government service, was sent to the White House counsel. And in that memo, Yoo sought to strictly limit the concept of torture, interpreting the relevant U.S. anti-torture statute so that only pain, quotes, associated with a sufficiently serious physical condition or injury, such as death organ failure, or serious impairment of bodily functions, end quote, could constitute physical torture. The legal analysis that Professor Yu employed to reach this conclusion has been widely criticized. Starting from the debatable proposition that the statutory requirement that there had to be severe pain or prolonged mental harm was inherently ambiguous, Yu looked for analogous definitions of severe pain in other U.S. statutes. He chose as the principal analogy a definition of emergency condition, entitling someone to obtain health care benefits. One commentator asks, is it a legitimate legal argument to infer from the emergency health care benefit statute to a definition of severe pain in the torture statute? End quote. I don't think so. The argument feels like someone went fishing around on a computer database looking to match up search terms, but did not exercise any practical wisdom or even considered judgment. The thrust of the legal advice being offered to U.S. interrogators was that aggressive techniques were necessary in the war on terror and that torture could be read so narrowly as to allow techniques that might otherwise be contrary to international or national law. By fiat of redefinition, in other words, and in the name of national security, no torture was being committed. Finally, I want to canvass explanations drawn from my analysis over these 3 lectures as to why these distinguished lawyers in the U.S. Department of Justice's Office of the Legal Counsel offered up arguments for the legality of waterboarding and other forms of aggressive interrogation techniques that seem so labored, so unconvincing. Well, one can start from the proposition that the al-Qaeda suspects were outside established frameworks of national law. Therefore, the society which gives context, shared understandings to law, became harder to identify. In a world that still accords so much value to the state, despite the many challenges to its hegemony, it's still easier to see fluidity and uncertainty in a society denominated international. The background is harder to discern. Therefore, the lawyer may assume a degree of interpretative freedom greater than when they operate within the bounds of a domestic system of law. Hence, the not entirely disingenuous arguments put forward that international law does not contain a precise definition of torture. Even in the Torture Convention, such a definition is lacking. But even when trying to define torture using American law, the OLC lawyers managed to play fast and loose with interpretative methods. One could defend their approach by suggesting that they were doing exactly what good lawyers do as part of reasoning through practice, exercising creativity in the use of analogy. How can one say that they went too far? Well, as I've already hinted, I think the answer is found in the concept of practical wisdom, that in situations of uncertainty, lawyers must be helped to develop the prudence to choose appropriately when the matter is not subject to calculation. As I've stressed, sophisticated practice requires not just creativity and flexibility, but pragmatism, connection to the impact of law in the world. In practice, lawyers must temper ideas with life experience. They create knowledge through the sharing of experience, not just clever constructs. The OLC lawyers found a way to argue that the definition of physical pain and suffering could be narrowed. Their argument was superficially creative, even clever, but it was neither prudent nor pragmatic because it was not judged against life experience. How else can one explain the anodyne descriptions of what happened to the suspects subjected to aggressive interrogation techniques, offered by Professor Yu and others. They're on record as saying, really, none of this had very much impact. Well, actually, it did in the real world. The disconnect between what those lawyers say they imagined and what actually happened to these terrorist suspects is extreme, because it seems that the lawyers had no relevant experience to call upon, and it seems also no empathetic judgment or moral imagination. How could that be? How could really smart people who'd gone to some of the very best law schools in the United States, taught by some of the most thoughtful law professors, lack pragmatic insight and moral imagination? If one reviews the criticism of North American legal education lodged quite consistently over the last 100 years, and I trace that out in the extended version of this, we can tease out a convincing and expansive explanation: the dominance of instrumentalism. In diverse ways, law students have been inculcated with the belief that law is nothing more than a tool. If law is merely an instrument to pursue goals outside itself, if it has no intrinsic value, the freedom to manipulate is almost complete. As long as one can make an argument, it's an acceptable argument, denying any evaluation of competent practice. And if the law is but an instrument, the important question is only, what do I need to do to have happen in law for my goals or my client's goals to be met? Without a widely shared understanding that the rule of law matters in and of itself, and that all people are both empowered and constrained by law, including political actors, people are subjected to torture. People die. Societies disintegrate. On the other hand, if a robust commitment to a sophisticated version of the rule of law is built up in legal education and in communities of legal practice, it can help buttress practices of legality that allow for healthy social stability while providing frames for evolutionary change. That rule of law can help to address and manage our current anxieties. I end by invoking the inspiring example of Hannah Arendt. You may have noted that I borrow from her work quite a bit. I find it so pertinent to our contemporary dilemmas. Arendt was a worldly German Jew who wrote her doctoral dissertation at Heidelberg on love and St. Augustine. Drawing on that work decades later, living as an exile in the United States, she reminded us of St. Augustine's pithy statement, that a beginning be made, man was created. Arendt argued that it is this very beginning that is the supreme capacity of humankind. Politically, it is identical with human freedom, she argued. Like Arendt, we must recognize the plurality of our world and of most national societies, and she did, and yet struggle to help citizens identify and build shared purposes through a mutual recognition of our equality. That requires active participation in society, upholding Arendt's free citizenship, not as submission to authority and power, but through reciprocal recognition by leaders and citizens of our mutual deference to a reconsidered, modest rule of law. Arendt reminds us as well that because of the inherent uncertainty of human relations in society, our actions have unpredictable consequences. To live together, we must work to forgive one another for mistakes made and consequences unintended. If we can manage that, defeating our era's easy recourse to constant blame and anger, together we can work our way through pervasive, debilitating anxiety. Let's begin. Thank you.
And so, since we have time, why don't we begin again in a few different places with your thoughts and suggestions, comments and questions to our lecturer. And I will bring you a microphone, and that way everybody at home will be able to hear as well.
For those of you who are watching online, the mic's just being delivered, and we'll do that for various questions. Thanks.
Thanks very much for a really compelling series of lectures. I was interested in your comments around the middle of your lecture today around drawing on Fuller on the way that law develops, and in particular your impressions about how judge-made law and law can change over time in connection with social practice. There's a line of scholarship that traces back to Jeremy Bentham that suggests that judge-made law, in particular things like overruling, coming up with new decisions or quashing governmental acts, violates the rule of law because of its retrospective nature. And in fact, in England and Wales right now, there's legislation before Parliament, the Judicial Review and Courts Bill, that is bringing in, or proposing to bring in, a new presumption that when courts quash government acts, the decisions apply prospectively without applying to the past, which is a pretty unprecedented reform. So I wonder if you could give some thoughts on the compatibility of judge-made law with the rule of law, and in particular the retrospective nature of it.
Thanks. So first off, I will say that I'm not in the tradition of Bentham, so we just disagree right to start. And I'm actually really concerned about the legislation that's been proposed in the United Kingdom. Now, that's not to say, however, that judges are completely unconstrained in making their judgments. And I actually try not, and you will notice, I hope, that I tried not to talk much about cases versus legislation. I actually don't think that's a helpful way of imagining what it is that's happening within legal systems. In fact, the argument that I'm trying to make is that cases, courts, decisions, and legislation and other forms of law, regulation, regulatory structures, etc., all have to participate in the kinds of criteria of legality that Fuller identified and that I've expanded upon. So there are actually, in my view, inbuilt constraints on judges, just as there should be inbuilt constraints on legislators as to what is actually law. And so I would go as far as to say, for example, that, and I've thought about this a lot in relation to international treaties, I could imagine international treaties which are formally concluded, actually ratified, etc., so under sources of law ideology, fully law, not actually being law in the interactional sense that I've described. And I think you can see exactly the same thing happen within domestic legal systems. I happened to be at the Supreme Court when a couple of cases related to abortion. I should say a clerk at the Supreme Court, when a couple of big decisions on abortion were made back in the 80s. And it was absolutely clear at that time that the abortion law of Canada was a dead letter already. So it was then decided, as you will well know, at the Supreme Court level, that the existing circumstances didn't support the law as it was framed, and therefore the law was struck down under the Charter. But what was so intriguing to me about that was, in many ways, the court was actually simply following what was already happening in society. And that's the argument I'm trying to make around shared expectations. Just as in capital punishment, sometimes things shift and the law actually is following, not leading. Now, there are other times when the law will lead. And I do think that that can happen both through legislation and through judge-made law. Interesting example might be the Ontario Court of Appeal decision on same-sex marriage, for example, which was really a moment that I think catalyzed social evolution that was, again, already taking place. But the judge's role was important in that catalytic way. So all of that to say, I don't like to get into a debate about whether legislatures or courts are more important. I think in our society they're both important, as are other forms of law. And I don't think that it's accurate to say, for example, that Dicey believed in absolute parliamentary sovereignty, even. There's a new book by Mark Walters. I don't know if any of you have seen it, but he makes this argument around what Dicey actually thought about parliamentary sovereignty, really undermining the traditional notion, which I was taught in first-year constitutional law, that in Canada, Parliament can, turn people's blue eyes into brown eyes in law, even if not in fact. Well, it turns out even Dicey didn't actually believe that.
Thanks a lot for the lectures. I wanted to ask you a little bit about the concept of practice and the practices, because it seems to do a lot of work in your theory.
It does, yes.
And I wonder then, how do you define the bounds of those communities of practice? Because the worry, the anxiety that you began with is that we no longer share the same communities of practice. We have different segments of society who have completely diverged ideologies and epistemic conditions. So what then is that background assumption that is doing the work in your theory, that epistemic community of practice within the rule of law itself? And the example that you gave about very smart lawyers working within the US Department of Justice within their own communities of practice. Mm-hmm. Presumably doing good legal work within their communities of practice that you, of course, criticize. So is there something there beyond smaller communities of practice, or is a larger community of practice that you think about?
No, it's a really important set of issues you've raised, and I don't think I can cover everything, but some observations. To start with the last point around this group of people operating within the Office of Legal Counsel, I think one of the challenges was that they were operating within a very narrow construct that actually didn't include what I would describe as the necessary challenges within a community of practice. So it's not that any group of people is a community of practice. If you look at the work of Adler, what he would say is that there has to be a wide-ranging group of people, some of whom have different opinions, to be in an effective community of practice. So one could say that if you step back for a moment from just the small group in the OLC and the people that they talk to a wider community of practice that included law professors, law students, the media. It's not just lawyers who are in legal communities of practice. It's a whole range of people who are implicated and interested in legal decision-making. And once you get to a wider understanding of the community of practice, well, actually, that is when the challenges did start. So the OLC developed this very narrow view, but it was immediately challenged by a wider community of practice that involved a whole range of social actors within the United States and indeed internationally. So I think you're absolutely right in asking the question, how do you define the community of practice? And I'll be honest, I don't think I could come up with a clear set of defining criteria. I think it's somewhat loose on the edges if you're going to have a community of practice. The second point I would say is, and Adler emphasizes this a lot, and I talked a bit about it last time, you can have overlapping communities of practice. So the communication that has to take place is not insular. It actually has to be open to challenge around the competency of the practice. And so there are people who describe landscapes of practice as a better way of thinking about what's happening in society. Now, all of this does actually require people willing to participate in a community that does include people who don't agree with them. And that is to your first point, I think. And I guess I just have to admit that. And so if one is operating in a milieu where only those people who you agree with are admitted into your circle of discussion, then that's not the community of practice that I'm describing. And I think we have to actually just build in our society to ensure that we don't. I mean, this goes to all of the issues around social media and whether or not too many people are operating in echo chambers, et cetera, et cetera. But I think the vision of community of practice that I'm describing does have the presumption that you're willing to engage in discussion with people you don't agree with. And if you aren't, then this starts to really have a lot of challenge. And so I think that's a kind of ethical commitment that we would be asking people to make in our society. And I think it's one that historically we have made, and I think we are at risk of losing to some extent. So I suppose in that sense I'm trying to build back towards places where we may have been historically and where we're less so right now.
Thank you very much, Stephen, for your excellent series of lectures. I've enjoyed all of them. I'd like to ask about your encouragement to help students see new legal arguments. Around the world, we are seeing a closing of the academic space with increasing threats to academic freedom that challenge the ability not only of professors, but also students to consider certain arguments. Could you say something about the role of the university in helping promote the rule of law, and what are the biggest challenges in this regard?
Boy, you're going to get me in trouble, I'm sure. Great, obviously crucial. So the starting point is universities have a fundamental role in promoting the kind of rule of law I've just described, for exactly the reason that your colleague raised in terms of thinking about communities of practice. I actually include law students, and I do this in the written version. Law students, law professors, practitioners, etc., are part of the legal community of practice, even if they're not practitioners. And I actually go through and distinguish between formal organizations of practicing lawyers, bars, and the kinds of communities of practice I'm discussing. They're totally different things. So everyone who participates in debate around law, even as a law student, is part of a community of legal practice. And so I think to the point about how you ensure that real discourse is taking place, you must, within the university, create the space for people to disagree. And if you have a circumstance in which people feel that they cannot contribute to the conversation because they will be attacked or because they will be undermined because of who they are, etc., that will fundamentally call into question the ability of creating the kind of community of practice that I'm describing. So I think we have a real set of challenges in front of us, because I agree with your analysis. There are pressures to create an environment where, and I talk to students who say this to me, that they're afraid to raise their hand in class because they're going to get hammered. And that somehow, as law professors, as practitioners, we have to find ways of keeping those spaces open. Now, that doesn't mean that people shouldn't be challenged. That's a fundamentally different thing. I think within a classroom experience, it is crucial in a university that people are challenged in their view, but they have to be challenged with a degree of tolerance or respect. And in a way, what I'm saying sounds like apple pie in the American terminology, and yet right now in our world it isn't, as we know. So I think it's incumbent on all of us to push hard to say, in universities, we are spaces where robust discourse has to be taking place.
So getting back to the idea of respectful discourse, you talked in your first lecture about artificial intelligence, particularly prediction machines, which is what most artificial intelligence is used for. And I'm not convinced that the world is so very different than it was before prediction machines and social media. But it's accentuated the tendency for people to only hear what they want to hear.
Yeah.
And so Is there a solution for that? I mean, you know, we can all talk about respectful discourse, but if the only fact set that we're arguing from is what the prediction engines have given us, how do you get respectful discourse? You get, you know, that's the sort of political divide we're seeing.
I mean, absolutely. And again, all three of these questions are, I think, intimately related. And I don't have an answer to that question, I'll be honest, except to say that what I've tried to do in the series of lectures is trace out ways of thinking that should cause us, I hope, to say to ourselves, we can't operate within these so-called echo chambers. If we're doing that, we're fundamentally giving up on competent practice within a whole range of fields, and I think especially within law. Because if we aren't actually hearing different views, having our own views tested, we cannot get to any form of pragmatic truth. It becomes impossible because pragmatic truth, as I tried to describe yesterday, must constantly be tested. That's the whole point of it. So you develop a frame that allows you to work in the world and allows you to engage with others. That's the point. And if you create a situation for yourself where that is not happening, then you are not creating communities of practice as I've described, and I think you're frankly letting go of a whole intellectual tradition that has, you know, done some pretty good work in the world over time. And so I'm hoping that if we can get people thinking about these issues in the ways that I've described, that the conclusion becomes, hey, it's not actually good for me to be only reading or engaging with people that already agree with me. Because if I'm doing that, I'm actually not going to be able to create a more robust conception even of my own truth. I wish it were easy, John.
Thank you, Stephen, for an excellent series of lectures. I want to take you back to the first anxiety that you referred to, populist nationalism, and ask you to give an example of the way in which your interactionist frame would challenge that massive anxiety that's facing us.
So I think it's a very fair question. I want to get something that doesn't require too extended an analysis. So what I think the interactionalist frame in law does is call upon us to investigate what it is that actually creates rules in law. Like, what is it that makes rules in law feel like obligation? And I think one of the challenges in the populist nationalist development is a presumption that it is only power that shapes social development. Only power, and that goes back to Schmitt, who I think is really the founder in many ways of at least the theoretical constructs around this. So a challenge which says, no, it's not just power alone that shapes outcomes, but that it's also other frames of analysis, including a modest rule of law that shapes healthy societies, would call upon a challenge to populist national rhetoric that says, for example, courts are inevitably bad because judges are not instruments of the popular will, or which says only legislatures which are dominated by a powerful force have the ability to create any kind of social cohesion. I think you have to again and again use the framework of interactionalism and pragmatism to say, no, that's a mistaken basic assumption. And therefore, in a way, it's almost the entire framework of populist nationalist rhetoric that has to be undermined. So I guess an example might be what's happened in Hungary around legislation related to universities, to the Central European University and others. So you would have to use this framework to say, just because Viktor Orban and his thugs, and I'll use that term, have legislative control, that doesn't mean that what they actually pass is valid, legitimate law. It can actually be questioned under the interactionalist frame. Now, that isn't to say necessarily that people will march in the streets. They may. It may be that's the only solution ultimately, but it may also be that you want to construct arguments around this that you take to the Constitutional Court in Hungary or that you take to other political actors and get an engagement that says just because populism right now is powerful doesn't mean it's legitimate within the system of constitutional law that exists in Hungary. So that'd be an example.
Thank you again for these wonderful lectures. I wanted to ask you if you could say a little bit more about your understanding of the relationship between politics and law. One way of framing that relationship would be to imagine a robust conception of the rule of law, such as you've presented us with, as a way of protecting us against a certain understanding of politics, so the kind of Schmittian view of politics as an arena of friends and enemies. But in the Arendtian or the Aristotelian conception of politics, it is the domain, the preeminent domain in some ways of phronesis. And so another way of thinking about that relationship would be to say that many of the arguments that you've made about the rule of law apply equally or even more forcefully to politics, to the role of the legislator. So, what kinds of qualities or characteristics do we need in our legislators and our politicians in order for your conception of the rule of law to function?
Thanks. So I do want to be really clear that I am not trying to set up a dichotomy which is law good, politics bad. But equally, I want to resist a fairly strong thrust in some political thinking that politics good, law bad. So in a way, I'm trying to overcome that tradition. But I think you're absolutely right. Part of what I'm trying to do is to challenge a particular view of politics as dominating over law. And that's the Schmittian view. So that's part of what I'm trying to do. But I completely agree with you that all of these questions also can be asked about the frame of politics as well as the frame of law. What type of people do we need? What kind of assumptions do we hope they will bring? What kind of judgment are we asking people to exercise? How is that judgment shaped? Is it just about a calculation of risk, or is there prudential judgment that has to be brought to bear? I think all those questions play out in politics just as they do in the legal system. And the other point that I hope consistently tried to make here is no frame of social organization is strong enough on its own to do all the work we need in society. And that's certainly true of law, but I think equally it's true of a caricatured view of politics, which is just popular sovereignty. So I am questioning the idea that politics is based only in popular sovereignty. And part of that, of course, is the whole question about minority rights and the will of the majority and how they play out and how you find the balances within both political and political legal structures. So I think I'm just agreeing with you to say that a lot of these questions really do apply within a political framework as well. And the argument is politics and law speak one to another, and they influence one another. That's why I always refer to the relative autonomy of law. It's not autonomous from politics, but nor do I think politics is autonomous from law.
Well, wow, what a week. And it's only Thursday afternoon. But before we go out into the evening sunshine, I would like to say another word of thanks to Dean Pro Tem Janine Benedette and to the School of Law for hosting us here at Allard. I'd like to thank you, our studio audience, for conspiring with our Clyne lecturer to to remind us all again, if we needed reminding, what a lecture at a university can be like, how that works, what a good feeling it is. And I'd like to thank those of you watching at home for your interest too. And as soon as conditions are fit, we hope that you'll join us out here for more of these kinds of occasions. Perhaps just one more quotation before we thank Stephen as uproariously as we can for his lectures. Just one more quotation. Nobody, I fancy, feels happy about the age in which we live or the future which even the living may know before they die. At all times in history, men and women have felt anxious about their own fate or the fate of their class or community. But there's seldom been a time, I believe, when the present and future of the whole human endeavor on this earth has seemed questionable to so many people. W.H. Auden, reviewing Hannah Arendt's The Human Condition, 1958, he goes on in characteristically perverse and provocative Auden fashion. Miss Arendt is not, of course, so foolish or presumptuous as to offer saving solutions, as if really any responsible philosopher in the mid-20th century would be so foolish or presumptuous as to offer saving solutions. I don't think even St. Augustine thought he was offering saving solutions. Now, Auden's stacking the deck a bit so that he can go on to say, no, she merely asks us to think what we are doing. We have, I think, once again, merely been asked to think, and to think really hard what we are doing, and to be very clear about the possibilities, liabilities of our human condition and the extraordinary privilege, the radical creative power that human beings have of beginning and beginning again. Now, Auden's writing a book review, and that is fitting too, not least because in regard to the book by Arendt, he said it's one of those books that makes him feel jealously possessive, like he'd like it just for himself and not to have to share it with anyone. A distinctly paradoxical thing for any book reviewer to say. The good news is that the book of this series of Clyne Lectures is one that you can possess in due course and also share. It's not out quite yet, but I don't think it'll be very much longer.
Who knows?
There is what appears to me to be a very complete typescript already. So all of those teasers about what Stephen has said in the more extended version of these remarks, they're not just teasers. The book is coming. And that will be reason to give thanks when it occurs. But in the meantime, we have so much already to be grateful for. Please join me in one more round of applause for our Clyne lecturer.